thank you. So I've got slides and I'll try to actually minimize that. So give me a little second. Hopefully I won't break anything. I should find them. Yeah, there they are. So before we start, I think that I need to tell. Oh yeah, of course. 2 seconds. So I'll share it this way and if I should say play from the start, I should come up. Can you actually see it?
Can you see it?
Not online. 2 seconds.
Can deal with it.
Please, thank you. Oh, yeah, that was the share screen.
Should we share PowerPoint?
Great, thank you so much. Thank you. So essentially, I'm sure that you can all see me. Before I start, I just wanted to say that I'm extremely happy to be here because, like, I've started in 2019, and all the conferences I attended, both as a presenter and just as an observer, were online. So at the moment, I can see real people, which is a great thing. So thank you very much for inviting me. And I'll try to quickly answer one of the problems of my thesis, which is competition law and privacy. Is it really a new problem or an old problem that kind of gone back? So as a starting point, we all know that competition law is now facing the challenges of digitalization. It's not really only the competition law that faces those challenges. Every possible grounds are facing these challenges. And from the competition law perspective, we got that the lack really of standardized approach. And there were many, many cases. So for instance, the German versus Candela against Facebook, which I call the Facebook saga, and this is where the entire drama started. And we also have the Google shopping case, for example, from 2017, which kind of proliferated debate. So at the present, we've got so many questions with what is really the relationship between competition law and privacy and how to really address it. So as a starting point, I always try to draw attention to competition law and two-sided markets because there are several market failures that arise in this problem. So before we start, what is the two-sided market? So we don't have really a set up definition of two-sided market. Acceptably, we have one company that kind of connects two separate groups of individuals. It could be, of course, two businesses connected to each other, or it could be like Facebook. Facebook connects us with the advertisers. Normally, wouldn't be, for instance, able to see those advertisers. But just because of Facebook, we can. And presently, we've got a couple of the market failures being recognizable, and those two can be compared into two elements. So firstly, we can recognize we have a market for privacy. And in this respect, we do have a couple of what I call drama on the market. So firstly, we do have a problem with of course, us being locked in and all the platforms and us actually being exposed to unfair terms and conditions. And we use Facebook because our family is there, and we also use Facebook because back in the 2008, everyone joined it because it was trendy and everyone wanted to be there. And we just remain there. So this is how we kind of got locked in there. And also just because everyone is on Facebook, that's obvious, it kind of created a natural monopoly. And since that, of course, it expanded all the networks effect, and we are still there. But the other side of the coin, we can argue that there is no market for privacy, because essentially we do try to argue that what is really relationship of privacy in the competition law. And essentially this argument has been put forward by Janos and Econovitis. They put forward an idea that we do not have a market for privacy, because essentially, technically, we do own the data, but we do not own that data. And at that ground, we can't really put forward any arguments in this respect. I agree with this reasoning, but essentially, there could be another side of the coin, which says that privacy can be actually seen as an element of quality. But we would get there. And this is just have to show you a nice, super simple graph or how the two-sided market models look like. I use Facebook because this is the best example. When we do use Facebook, we kind of agreed for them to take our data also from third-party websites. So sometimes randomly when we browse for perfumes, let's say, suddenly Facebook is extremely clever and gives us an idea to order a sample of the perfume. And that happened to me so many times. But what really is the judicial interface? So how did we come to the moment we are at the present? And there were several case law that is kind of brought forward. So the starting point is that, which I call the step one, competition law and privacy were seen as two separate regimes. And this is where we have the famous case of Asnes Exquitas coming in, which says that privacy and, well, data privacy, which covers data protection, and competition law are two separate areas of law. And essentially everything that happens there and we breach any data protection aspects, this is for the data protection organizations and authorities to look at it rather than for competition. But just because we're quite more interested in Google and all the big techs, there's another case of Google and double click mergers. And essentially, their case kind of brought similar idea to what we're discussing as the Equitics. Again, the same reasoning. We could do anything from the competition law perspective because those two areas of law are separate. But the step two, this is what is kind of getting more interesting. This is where we see privacy as a main, but not main, but important parameter in competition law. And that paradox can be seen in two merger case laws. So the first case we will look at is the merger of Facebook and WhatsApp. So what happened there? Essentially, from the perspective of the data, the EU Commission says that regardless of whether the merged entity will start using WhatsApp user data to improve the targeted advertising on Facebook's social network, there will continue to be large amount of internet data users that are available for advertising purposes are not within the Facebook executive control. And it was obvious. So this is kind of the moment we had the data being recognized as something that could be enlarging the power on the market. Nevertheless, when we do look at the concept of privacy, we're still deeply in the forest, absolutely lost. The picture was showing as to, contrary to what WhatsApp Facebook merger enables Facebook to collect data regarding its users for its advertising purposes. So again, we kind of see that they recognize something. But if we actually do look at what happened in relation to the privacy, it's still not much being discussed. With the aspect of the case was really that the main driver of competitive interactions were the underlying network and functionalities offered by the platform, nothing about privacy. But at the end of the day, when we do have a look at the case, we can see that the Commission concluded that privacy was a main driver of competition in consumer communication market. And why privacy could have been seen as this? Because essentially WhatsApp is still kind of the most private messaging application. So this is why they potentially reached this idea. But if it comes to the actually elaborating on privacy and competition law, not much. And later on, we have the Microsoft LinkedIn, and this is where we have a slightly more mature approach to the case, comparing to the case I've just discussed. So essentially, in this case, we reach to the decision that privacy-related concerns as such do not fall within the scope of the EU competition law. And we're still back to the Asnet Exquitas reasoning, deeply in the forest, totally lost, we don't know what to do. But they went to continue, but can be taken into account in the competitive assessment to the event that consumers see it as a significant factor of equality. So we have something new introduced. And the merging parties compete with each other on this factor. In this instance, the Commission concluded that the data privacy was an important parameter of competition between professional network on the market, which could have negatively affected that transition. So even though we are still in a reasoning of Asnet Exquitas, we have this important aspect being brought forward. Privacy could be seen as a quality parameter in a competition law. But how it evolved further? Furthermore, of course, this is just to conclude what I've said, which and underline that main argument. This is an important parameter of competition law. But how it brought us to the moment we are at the moment. We have the famous Facebook case saga. Why saga? Because we have a couple of those cases being brought forward. The first one, which is kind of the one that made me to do the PhD in this, was the 2019 reasoning from the Bundeskartellamt. And this is where we have them trying to see that any combining of of data could potentially both infringe competition law and data protection. And again, this is a super lengthy case, quite interesting. And we can actually see that the Bundeskartellamt look at the exploitive theory of harm, saying that just because they implemented that data policy, they collect our data, we are unaware, they go big. two sides of coins are being breached, both competition law and privacy protection. And I looked at the case from the perspective really of European Commission to say that potentially we can look at the exploitative trading condition as per case of Sabam, or we can actually then case by case we could potentially reach the conclusion that privacy and a competition law sphere could be seen as a vain and exploitative abuse. Later on, of course, the case still got to Düsseldorf court, which was kind of changed, and then we've got the 2020 decision. And at the end of the day, the case is now referred for the preliminary rulings at the European courts level. So we still need to figure out what they're gonna say. But eventually, this is still like them trying to find out how to merge competition law and privacy together. So this is where the next question will arrive, with how to merge competition law and privacy together. So we had everything mentioned, that yeah, it could be privacy, could be a main parameter, but not important, but how to actually merge it. So there are two ideas that could be really brought forward when we try to see how to merge those two together. There is separation and integrationist views, and there's also a privacy as a quality parameter. So starting briefly with separationist and integrationist views, I'm trying to actually run it quickly so you, because I probably ran out of time already. So essentially, those two opposing views are quite being seen as something we've discussed in the competition law before, as to whether we can bring any policy consideration into the realm of competition law, but now we do it from a more likely perspective of competition law. Arguably, the separationist views will consider the Asnet ex Quitas case as a heart of the debate, just to say that those two are completely different in nature, we can't do anything. But on the other hand, we also have the integrationist approach, which accepts incorporation of privacy into the competition law framework. And again, like what I mentioned, this is really an idea of a long-standing debate whether competition law could include any non-price elements in a substantive analysis. So based on this, both price and non-price factors could improve the welfare of the consumers. So, for example, in 2014, there was a report being published which actually concluded that privacy and protection of personal data should be considered as a non-fundamental concern, but rather as a central factor in appraisal of companies' activities and their impact on competitiveness, market efficiencies, and consumer welfare. Of course, like this is given that consumers are also data subjects, whose welfare could be, of course, at risk, where freedom of choice and control over personal data will be, of course, impacted negatively by the dominance of the undertaking. But essentially, at the present, really, several academics really put forward that we should really consider more likely the integrationist views rather than separationist views. But before we get into the moment why they do think about this, we need to speak about some central disagreement between separationist and integrationist approaches. So really, the idea is whether privacy could be a factor of competition law. Those both teams try to answer this problem. And of course, this is a valid question. However, this question does not consider the intersection really between the competition and privacy, but it also considers if privacy could constitute a part of a competitive theory of harm. So essentially, this remains unclear, and this is what I'm trying to actually assess in my thesis. If privacy amounts to quality factor, or a differently orientated factor is still a question mark, and we need to dig more into details to make sure that we can figure out. Yet the argument that these two areas of law could intersect remains true, and the argument does not provide there is a hard contrary law which competition law requires action that data protection prohibits. It is of course also accepted that those two regimes of law intersect each other at the time, and that also could be seen as different. And at the end, like, I'm not trying to actually say that those two views are completely separate and they shouldn't be taken into account, because before we reach the decision, we need to listen to those two teams to make our reasoning. And why we do think that the integrationist approach is kind of more likely to be accepted because of the privacy as quality parameter. And why? Because Privacy of voice is one of the most widely articulated perspective on the relationship between competition and privacy. This really would underline that privacy as an element of consumer quality. But again, this brings up a huge question for the competition law sphere, because we do not have an accepted framework of how to assess competition and well, privacy as a quality parameter. And even though it was accepted, because we just seen in the judicial reasoning, but we don't really know how, and there's still missing of any engagement from methodological side. Essentially, everything beforehand based really on the prices, and well, in a digital economy, everything is now free. So essentially, this is the question. But I said, but if you do dig further, consumers now bring forward an idea that they are more overlandly interested in actually making the search history, for example, being more private. And I found an interesting study by Tsai. So Tsai and her team looked at what are the behavior of people online. And those people who were actually looking for sex toys were kind of more vigilant to show that to Facebook and any different platform, comparing to everyone else who was, for instance, looking for car insurances. But at the end of the day, there is still a question on how to match those two together, because we of course lack any methodology on this aspect. So to bring us to the conclusion, we have two distinct levels of problems at the practical and at the policy levels. Case law, we do try to reach the idea that we recognize privacy and competition law together, but at the end of the day, practically, we don't know how to do it. The problem really is, could be amounted to structural problem of ignorance, because we do have notice and consent privacy models. We don't read those terms of condition because some people might potentially lack a mental capacity to read them, and they're also very lengthy, and we do not really have a time to spend 2 hours reading the Facebook terms of condition, which still doesn't provide us everything to what they do with our data. And really, the problem here, even if the people would try to say that those two are separate, I would say that the problem is really between, for both competition law and for GDPR, because again, we do lack any methodology to assess those two. And from a competition law perspective, we need to see how privacy could be seen as an element of video harm before we can do anything. Right, thank you very much. So I will try to stop sharing. And I'll switch this off, sorry. So